Hello friends, welcome to Varical's Learning Vlogs. This is CA Prince George and it's my Income Tax Act 1961 learning series. Today we are going to study section 6 that lays down the rules to determine residential status of a person. And with this we will come to an end so far as chapter 2 basis of charge is concerned. I have been telling this that chapter 2 is a very important chapter. It forms the foundation for learning income tax law, and section 5 is the heart and soul of this chapter. It's important to do a very quick recap of section 5 to set the right context to learn section 6. So section 5, it gave us two fundamental principles on which the entire levy of income tax on income is hinging. The first principle was with respect to the point at which incidence of tax will fall on income. So income tax will be levied on income when income is received, when it is accrued, or when it arises, or when it is deemed to accrue, arise, or receive. And the other principle was that the taxability of income will depend on the residential status of the person. So if the residential status is that of non-resident, the taxability will be least. If the residential status is that of a resident, taxability will be highest. The global income will get taxed. So with that background, now let's understand what are the rules to determine this residential status. Before that, I would like to give some clarifications on certain terms which are very often used by all of us, and sometimes it is misunderstood with that of residential status that we learn in Income Tax Act, that is section 6. So the first one is citizen of India. Now citizenship is entirely governed by Part 2, Article 5 to 10 of the Constitution of India, and also Citizenship Act 1955. It has nothing to do with the residential status as provided for in Section 6 of Income Tax Act. Citizenship is the highest form of political status that a person can get. If you are a citizen, there are a plethora of rights that you will have: right to vote, right to acquire property, etc. Whereas the residential status is a status for the purpose of determining taxability. It doesn't give you any right, and it is exclusively governed by Income Tax Act 1961. It depends on your number of days stay in the country. The other term that I want to clarify here is PIO, person of Indian origin. Now again, this and residential status are different. PIO is governed by Citizenship Act 1955. You have a PIO card, person of Indian origin card, which is issued by the government of India. PIO is again very close to being a citizen, but you are not a citizen. You don't get all the rights. It is also a political status that one gets, but you don't get all the rights of being a citizen. For example, you don't get the right to vote, you don't get the right to acquire agricultural property in India. The other one is OCI, Overseas Citizen of India. Now again, this is also sometimes misunderstood with the residential status in Income Tax Act. OCI is, again, it is a political status that one gets. It also gives you a plethora of rights, but those rights are not equivalent to the rights that a citizen would get. This is governed by Citizenship Act 1955. It has recently introduced Section 7A under the Act, with which this concept was introduced, and it has replaced the PIO which earlier we had. Now the Government of India is issuing OCI card, Overseas Citizen of India card. Again, they cannot vote, they cannot acquire certain kinds of property, but you get a permanent visa with OCI, with being an OCI. The fourth one is non-resident Indian, NRI. Now this is one term which is extremely loosely used for everybody who has an Indian name and he stays outside India. And this is more misunderstood to be a non-resident as is defined under the Income Tax Act. Income Tax Act doesn't define NRI. It defines just non-resident and resident. It doesn't define non-resident Indian. So I don't know where NRI as a term is defined, which statute defines it, but there is a closely resembling idea in FEMA, which is person resident outside India or person resident in India. And I have seen couple of RBI circulars where non-resident Indian term was used, but I could not find any definition anywhere. Nevertheless, it has nothing to do with the residential status as you see in income tax law. So we will find some of these terms being used in section 6 also. This will also give you a background of understanding those terms there, right? So let's start with section 6. To begin with, we are going to study the residential status of an individual today, because this is the most complicated, complex provision that we have in section 6. We are not going to study residential status of other types of person that we will pick up in the next video. So section 6 subsection 1 says that an individual will become a resident of India if he is in India, that means physically in India, for 182 or more days during the previous year, or for 365 for 60 days or more during the previous year, and 365 days or more in the previous year preceding the previous year. So for example, if a person stays in India for say 190 days in the previous year 23-24, then he becomes a resident. And once he becomes a resident, all types of income everywhere in the world will be taxed in his hands. Now suppose the same person is not in India for 190 days in the previous year, but he is there for say 65 days. But in the 4 previous year preceding this previous year, he was in India collectively for 365 days or more. He still will become a resident, and the world global income will become taxable in his hand. it is immaterial whether the person is a citizen or a non-citizen with these two criteria. Now there was a problem with these two criteria. There were many situations when just by applying this one of these criteria, if a person becomes resident, it is extremely unfair to that person, to that individual. Let's take example of Beatles, the famous music band from US, from West. Now they around 1968, George Harrison and Paul McCartney of Beatles, they were in India in one of the ashrams. So they had come here to seek spiritual guidance, to learn about Indian culture, Indian spirituality, and they stayed, I think, somewhere in Rishikesh, in Maharshi's ashram, and they were here for 8 to 9 months. Now they were here for that 8 to 9 months, whatever that period, only 1 year. That was in 1968 or 1967, just one of the years. Now by virtue of being in India just in 1 year for so long, so they have crossed 182 days if they are here for 7 or 8 months. But by virtue of that, they ended up becoming resident of the country. So in absence, because of this provision, they will get taxed even for their global income. So somebody who had come to India to seek some kind of wisdom, some kind of guidance, spiritual guidance. Now suddenly when they go back home, a notice from the income tax department follows them that, see, you have come here and we gave you spiritual guidance, everything is fine, but now you have become the resident here, so you have to pay tax on the income, on all those global concerts that you have done everywhere in the world. Now this is a very ridiculous situation where somebody who did not have any economic connection with India now will have to go and pay tax on the global income. And this is just one example of Beatles that I gave. There are thousands of such people who come to India in any one of the years and stay here for a very long period. Their intention is not to forge any business tie with India or explore business opportunities in India. Their objective is just to come, relax, have leisure time, seek spiritual guidance. You will find plethora of such people when you go to places like Rishikesh or such ashrams. You go to ISKCON, you will find such people. You go to the ashram maintained by Amritanandamai, Sadhguru. You will have hundreds and thousands of such people in India who are seeking some spirituality. So it's very unfair, very unjust if we start taxing them. They will run away from the country, they will never come back. We will lose on important forex that we have been gaining from them. Same are the case with so many tourists who come in Goa, for example. There are old couples who come, who stay here. They have come here to spend money on the income that they have earned all this while in their life and just have a good time. But we start taxing them, which will be wrong. So then another category was created, which is called resident but not ordinarily resident in India. And if you are a resident and not ordinarily resident in India, your global income doesn't get taxed. What you have earned outside India doesn't get taxed. We have studied that in section 5. Only if any income is received, accrued or arises in India, that is going to get taxed if you are a resident but not ordinarily resident in India. So the section says, another section, subsection, that if irrespective of how many days a person has stayed in the previous year, if that person has been a non-resident in 9 out of 10 previous years preceding the previous year, he has been a non-resident in 9 out of 10 previous years. Or if the person has been in India for 729 or less days during the 7 preceding the previous year, then the person will be considered as not resident but resident but not ordinarily resident in India. So by giving this status to the individual, all the global income that the individual has earned can be avoided from getting taxed. Only if they are earning something in India, they will be taxed. That is fair. Now there are some more exceptional cases wherein it fell to the legislature that it is unfair, unjust to tax in those situations. One such situation which is provided for in the provision is, in section 6, is that of a member of a ship crew. Now there are many employees who are employed in Indian ships, and typically the way this merchant navy business works is these employees are in the ship for half of the year, 6 months, and the remaining 6 months they are in India. So it will be a little unfair again to go and tax an income which such employees have not earned in India, income that doesn't accrue or arise in India. They are arising this income outside India when they are in the ship. The salary that they earn in the ship is when the ship is outside India. It's not in the territorial waters of India, it is outside India. But because of the two basic criteria, if the person is in India for 60 days in the previous year and 365 days in the preceding 4 previous years, he or she will become a resident of India. And as a result, the person will end up paying tax on that income as well. So the government said that fine, in case of a member of ship's crew, if the person has stayed in India in the previous year for less than 182 days, then the person will not be considered as resident. So the 60 days criteria is replaced with 182 or more days. Now this was fair for them. Similarly, so as a result, if they are non-resident, the salary that they are earning in the ship outside India will not be taxed. Another situation was with respect to employees or with respect to individuals who go out for employment. Now again, just imagine a situation, and there are plethora of such situations where a person who was uh, in India, say in April, May, and June, just for 3 months, and in July the person flies to, say, US or Dubai, outside India, for employment. He got a permanent employment there, and now it is the person's first employment in this example, and uh, is earning income there, is rendering services there and earning the salary there. But because he has been in India for 60 days, more than 60 days now, April, May, and June, and of course in the preceding years he was always in India. By virtue of this criteria, that person becomes a resident and will get unduly taxed for income, his first salaries that he has been earning in other country. So this was again considered an unfair treatment. So even in this case, an exception was provided for, that unless the person stays for at least 182 days, the person will not be considered as resident. And then that was quite fair. The other exception which was provided for was again in situations like where a person who is a citizen of India or a person of Indian origin who visits the country to meet parents, to meet grandparents, and there are so many like that. And often these people would come and stay here for a longer duration. Now, by virtue of again the same basic two criteria, it will be unfair that if the person becomes resident here, his global income gets taxed. Now, so in such cases also it was called out that unless and until such individual stays for 182 or more days, the individual will not be considered as a resident. He or she will continue to be a non-resident. So these were three exceptions which were provided for in case of individuals who are citizens of India or person of Indian origin. Now, if the same individuals who are citizen of India and or a person of Indian origin, if they have income from any source in India, which is 15 lakhs or more, then there is another further provision which says that in such a scenario, if that person is staying in India for more than 120 days, 120 or more days, but less than 182 days, the person will be considered as a resident, but not ordinarily resident in India. So the person is no more now a non-resident. Till now we were treating the person as a non-resident if the person is staying for less than 182 days in India, if it is an Indian citizen or POI, person of Indian origin. But if you have a source of income here in India, and which is 15 lakhs or more than that, then it is believed that you have some economic connections also with India. It's not just emotional tie-ups, it is some commercial interest also in India. In that case, it will it will not be right if the status of non-residence is accorded to that person, because now that person is a little more than non-resident. Now he is resident, but not ordinarily resident in India. And it was important to have this provision because this was later on introduced. It was not there originally, because there were many high net worth individuals who were using the loopholes which was provided for as a relaxation to citizens of India and person of Indian origin, and using that to evade tax by way of changing their residential status. So that's why the government said that fine, if you have some commercial interest in India, then, and if it is more than 15 lakhs or more, then you should be treated as resident, but not ordinarily resident in India. So by having this status, your global income will not get taxed the way global income of a resident get taxed. Your global income will get taxed only and only if it is from a business which is controlled from India, or from a profession which is set up in India. Where a person, say for example, a person is a person of Indian origin, he is based out of, he is from Kerala, and he is a scientist in ISRO. There he gets handsome salary. Now if that person has a property in Kerala from where he is earning rental income, and he is earning, say, rental income to the tune of 20 lakhs. Now because of this rule, the salary that he earns from ISRO is not going to get taxed, because that is not a salary that he is earning from a business which is controlled from India or from a profession which is set up in India. Salary he is earning there, it is not going to get taxed in his hand, because his residential status is changed to resident but not ordinarily resident in India. It's only where he also has some business outside India along with earnings, say salary from ISRO, some business also he has which is being controlled from India. Now that business, income from that business will get taxed here, which is very fair. So that was an exception which was a carve out which was provided for within this exception, and which is only in the case if a person is a resident, if a person is a citizen, or a person of Indian origin. Now again there is another section which was subsequently inserted, section 1A, which provided that where, owing to the domicile of a person, individual, or residence of the individual, or similar other statuses, if a situation arises where a person doesn't have to pay tax anywhere, he is managing to avoid paying tax in any country, say because he is physically situated in a place where first of all there is no tax in that place, and the arrangement is done in such a way that wherever he is earning income, he happens to be a non-resident or non-domiciled person for that country and ends up paying tax nowhere, that person, such a person will be deemed as a resident in India if he has 15 lakhs or more income arising from a source based out of India, source in India. So such person will be deemed a resident, but a not ordinarily resident in India. So that was all for residential statuses of an individual. It is quite complicated in terms of complex requirements and sub-requirements, caveats. So it's important that we keep this studying again and again, provisions, and try to interlink the provisions and study. So fine, thank you so much, friends. We'll in the next video we'll see how do you determine the residential statuses of other persons. All for now. Thank you so much. Do leave comments if you have any doubts, queries. Thank you.